A man from West Seneca is relieved after a big win in court. He had faced charges of criminally negligent homicide after he shoved an elderly man who fell, hit his head on the floor, and died from his injuries. But a judge has now dismissed the indictment. This all went down inside a local bar, and you might remember the case because witnesses said that the fight started over an argument over mask wearing. 2 on Your Side's Dave McKinley spoke to the defendant's attorney about the judge's decision that found there just wasn't enough proof in this case, and also prosecutors may have messed up while presenting the case to a grand jury.
Witnesses say that in September 2020, inside this bar on Southwestern Boulevard, 80-year-old Rocco Sapienza began badgering Donald Lewinsky about his not wearing a mask and wouldn't let up.
Hour after hour was threatening to beat up and kill my client, saying, "I'm a Marine, I'm going to kill you."
Witnesses said at one point where Sapienza had cornered Lewinsky and continued the threats, Lewinsky pushed him. Sapienza fell back, hit his head on the floor, and died, and Lewinsky found himself charged with criminally negligent homicide. But in a 9-page decision, Judge Sheila DiTullio noted that to sustain that charge, Lewinsky or any reasonable person would have had to perceive that shoving Sapienza presented a substantial risk of death.
And it was not even, as the judge says, something that the average person would deem to be a possible result of pushing someone.
And while it could have been had Lewinsky shoved Sapienza down some stairs or in front of a passing vehicle, as the judge wrote, there was no such additional affirmative act on the defendant's part. There are laws in New York State regarding the assault of elderly people which can enhance criminal charges. But as the judge wrote, despite the people's assertions regarding the victim's advanced age, there is no evidence that defendant even knew the victim's age or that such advanced age could be readily discerned from his appearance or comportment.
And as the judge noted, the victim was a healthy appearing, well moving as he approached my client from the other side of the bar.
And as Covert noted, at age 65, his client was technically of advanced age himself under the statute. Prosecutors had also asserted that Lewinsky had some sort of duty to retreat when set upon, but Covert says he couldn't because he had been cornered by the victim.
And there are numerous witnesses that all say that, and there's videotape supporting that.
The judge further wrote, it also was in error for the prosecutor to fail to instruct the grand jury with respect to the defense of justification.
The prosecutor has an obligation to instruct the grand jury that they can look at whether this was self-defense.
But it did not, which Covert says was grounds enough to get the indictment tossed.
And Dave joins us now. So you kind of wonder what the district attorney is saying about this. I mean, he clearly lost this case now, right? It's been dismissed against the defendant. And especially considering the judge is saying your prosecutor's kind of messed up here.
Yeah, right. An indictment of the prosecutors, if you will. Well, Michael, we did reach out to District Attorney John Flynn for comment, but his office said he would have none, only confirming they will file a notice of intent to appeal this ruling.
Meaning it could be, at least allows them to appeal should they go down that route.
Reserves their right if they want to try it before the 4th Department Appellate Division in Rochester. I don't think they've done that yet, and they may not have decided whether or not.
But they can.
They can always
if they choose.
That's their choice to try to appeal.
All right, Dave. Thank you very much. Coming